That was exquisite. Thank you so much. Thank you all for being here, and thanks especially to my Radcliffe fellows and to the Radcliffe staff that humored me when I said, could we possibly make it a more inviting space? So it's really an honor to be here, and I'm going to start by saying, forgive me. Forgive me if I miss the mark or otherwise disappoint. Think about that phrase. Forgive me. How often have you said it? These are the words that we use when we arrive late, when we need someone to repeat a phrase that we didn't hear well, when we do something much more egregious. These are the words that are familiar in the prayers of so many religions. These words are steps towards repentance and redemption. Is forgiveness between people something so worthwhile that government, courts, legislatures, juries, public officials ought to encourage it? Should law itself be forgiving? Forgiveness, as I use it, means letting go of justified resentment or grievance. The justified part is pretty important. If it's not forgiveness, if there's a defense, if there's an excuse, if there's a ground to blame the other one. Requests for forgiveness fill art, including lyrics of pop culture, detailing mistakes and apologies between lovers, parents and children, citizens and governments, individuals and their gods. Victor Hugo's classic novel, Les Miserables, who's read it? Who's seen the show? Okay. The story illuminates the human costs of an unforgiving law. It imposes those costs not only on the criminal defendant, but also on the law enforcer. In its climax, spoiler alert, the escaped convict Valjean mercifully spares the life of the police chief who has spent years pursuing him, shocking the man of the law with the power of forgiveness. Whether to forgive and why is a theme in entertainment, in relationship advice, religious counseling, and political drama. And when a high government official is caught in a personal or political scandal, journalists and philosophers and bloggers and family and friends discuss whether and when such a figure should be forgiven, and if so, by whom. Forgiveness expresses a generosity of spirit and a constructive focus on the future. It's potentially a non-depleting resource, offering physical, psychological, and practical relief for wrongdoers and for victims of wrongdoing. And it's not just for people. One thing that I've been able to do during my Radcliffe Fellowship is read about how animals strengthen their social relationships through acts of consolation and attentiveness, often taking the forms of grooming and stroking and sexual conduct, not exactly what people do all the time, but it reduces tension and strengthens community and peace and social integration. And maybe biological evolution developed forgiveness as a survival tactic. But forgiveness has its limits. Mass murders, rapes, abduction of children, genocide. Some acts defy conception, not to mention forgiveness. In these circumstances, private or public pressure on a victim to forgive looks like a new victimization, denying the victim her own choice. Pressure to forgive unfairly targets some people more than others. Some people may not feel very forgiving, and I know about that because I drive in Boston. It's even harder to figure out whether and when law itself forgives. Can a government forgive on behalf of its citizens? If courts or prosecutors forego warranted legal consequences for instances of wrongdoing, does that jeopardize adherence to rules, to deterrence, and the commitment to treat like cases alike? My work asks whether and when law should encourage people to forgive one another. Should law itself be used for people to encourage people to forgive each other, and should law itself forgive? I am focused on criminal law, both in the United States and internationally. And internationally, that means crimes against humanity or other very serious offenses. And I'm also focused on debt. It may seem like an odd conjunction, but think about it. It's not by accident we talk about forgiving a debt. And in my efforts, I'm looking at consumer debt, debt produced by the legal system itself, like fines and fees, and sovereign debt, debt incurred by states and municipalities and nations. Also of interest, everywhere I look, I see questions of forgiveness. Should the government forgive violations of immigration law? Are there limits on the pardon power of the president? Will the growing use of algorithms in law permit more forgiveness or restrict it? Now, lawyers like to focus on particular cases. This gives us context. It also means that we actually realize at the end of the day there has to be a practical decision. Let me share with you a tough one. Like many legal problems, it has disturbing elements. It involves a killing of a person with disabilities. It presents troubling legal and moral questions. And warning, I'm going to ask you your views very soon. Louis Rupuy, an immigrant to this country, sought to become a naturalized citizen. The governing law, then and now, requires that such applicants demonstrate, and I quote from the statute, good moral character. Good moral character. During the 5 years preceding the application. Unfortunately, 4 years and 49 weeks before his application, Mr. Rupuy engaged in an act that led to his prosecution for murder. What was the act? He used a drug to put to death one of his 5 children. The child was then 13 years old, had severe brain damage, was blind, unable to communicate or control his bodily functions, feed himself, or move. Mr. Rupuy was indicted for manslaughter in the first degree. That means that the prosecutor viewed it as a serious offense, but less serious than murder or first-degree homicide. He was charged with the crime of killing a person when there are mitigating circumstances. A jury agreed and disagreed. The jury convicted him of manslaughter in the second degree, which means a killing reflecting recklessness or negligence rather than an intention to murder. Not exactly suited to the circumstance. The jury did something very unusual even beyond that. The jury wrote the judge a note and said to the judge, please use the utmost clemency. The judge, in turn, stayed the sentence, which means suspended any punishment, and placed Mr. Rupuy on probation, which he served. And that was the end of the criminal case. 4 years and 49 weeks after he killed his son, Mr. Rupuy applied to become a United States citizen. And now we come to the question, what would you do if presented with his application to become a United States citizen? How should we view what happened in light of the legal standard requiring the applicant to prove good moral character in the prior 5 years? Yes or no, good moral character, enough to become a naturalized citizen, and why? Okay, I'm going to ask you to talk to your neighbors about this. At least one other person, no more than 3 others, okay? All right, are we ready? What did you think? I mean, actually, there's several questions here, right? So what did you think? And you can tell me what you think the questions are, too, right? What do you think? Well, and what's the right answer? But you can also frame the question. Liz?
The law doesn't say legal, it says moral.
Correct.
And so one then would be making a judgment about what the moral situation was, and clearly the jury was making a recommendation based on a definition of morality, that they felt that they had made the moral choice, right moral choice.
So you would say, go ahead and grant him citizenship. Okay. Yes?
Is it more or less moral because the child has brain damage as opposed to putting someone in a wrong environment?
Right. That's a tough question.
Did he, this is my husband's question, did he turn himself in and say, I did this, I know it's against the law, but please have mercy?
Good
Or
question.
did he try to conceal
Okay.
his killing the child?
Lots. Okay. Good question.
I have a question what was his intent for killing his child? Was it really that he felt it was a mercy killing, or was he just sick of the burden?
Right. Okay. So people want to know more. Michael?
Was it actually requested by the child in whatever form and communicate?
What this child could not communicate in any way. That one I know the answer to.
Can we please wait for the microphone?
Mike is
just so we
coming to
can-
you. Sorry.
No, I asked the question, cultural context. So his actions in a different culture may have been considered ethically okay.
Such a great question, and after all, he's an immigrant. And so by which country's standard should he be judged? Nope.
What did the mother think?
What did the mother think? That's a good question. And one more?
Besides the circumstances of his killing, the question before us is whether he should get citizenship.
Yes.
And considering how many citizens we have that are wingnuts that run around killing people on a daily basis, a weekly basis apparently, it's hard to draw the line on the citizenship question here. So to me, besides what we might interpret into the case about the condition of that child, the citizenship question is separate, and I have no problem granting him citizenship.
And should the morality be tethered to the average of existing citizens, or should it be something quite different, right? Yeah. Yeah.
I'd also say with respect to the legal moral component, the jury, what they convicted him of implied no malintent, in that it was negligence as opposed to first-degree manslaughter, which is malintent oriented.
Right.
So that also probably plays into the, moral, I don't know if we can use the conviction as a standard of his moral conduct, in that what he was convicted of has no moral component to it.
Great.
Does it matter? And I would think it does. Of what was the method? I mean, he didn't do something cruelly. He didn't have a machete.
Chloroform.
Okay, so it was a painless
Yes.
death, as far as we would know.
As far as we know. That's right.
I would like to know what else he did during the 5 years, not just this one issue. And secondly, to really think about whether good moral character is merely the absence of bad.
These are deep questions. Look at this. Look at this. Shafi.
The way you frame the question is, what would you do?
Yes.
And I would not let him in the country, because I think that this is so beautiful as a discussion, but there's so many people who want to gain entrance to the US, and you gave us such an extreme case, which is very ambiguous. I think it's a very clear answer.
Okay, great.
I think it's also a very fundamental question about the nature of criminality and whether the occurrence of a criminal offense is likely to indicate that there'll be criminal behavior in the future, whether there's almost a notion of a propensity to immorality that is indicated by a previous offense.
Great. We obviously could spend the entire time talking about this case. It's a very fascinating and hard case, and you have done better than the court did. The appeals court didn't know what to do. I really want to tell you, this is one of the most puzzling decisions I've ever read. I think we have before us so many wonderful questions that you've asked, and at least one set of questions is, what, if any, role should that prior criminal case have in interpreting the standard for the immigration case? Another question is, what is good moral character? And even behind that, how would we know it? Is it philosophic? Is it sociological? And of course, would you grant the citizenship or not? So I can tell you that what actually happened, if that's of interest, is it of interest? Yes. So the case first went to a trial court, the federal district court, which said, yes, he has demonstrated good moral character and ordered that he be granted citizenship, very much as Liz suggested, looking at what the prior jury had done and what the judge had done in that case. The district attorney appealed the case, and it went to the Court of Appeals for the Second Circuit, where 3 judges clearly disagreed with each other over what was good moral character, over whether courts could answer it, and over what to do. And I'm going to read to you from the majority opinion. Left at large as we are without means of verifying our conclusion and without authority to substitute our individual beliefs, the outcome must needs be tentative. It gets worse, and not much is gained by discussion. The court basically said, this case is too hard. We can't decide. And then, because it was unclear, this is where lawyers have ways to deal with things like this, he loses. Because it's not clear, he has failed to persuade the court that he demonstrated good moral character for the prior 5 years. It was his burden to persuade us. But the appeals court goes on. They say, but 3 weeks can go by and he can file again. Then the conduct falls outside the 5-year period. What are we to make of this? It's authored by a distinguished judge with a very curious name. The name is Learned Hand. Can you imagine being in elementary school with that name? Anyway, the court did not forgive the lawyer's mistake in filing the petition 3 weeks earlier. Clearly, this was a mistake by the lawyer, right? The court was not forgiving about that. Okay? Point one. However, the court offered forgiveness in saying, file again. Without prejudice, the court specifically said, allowing it to be filed again. The dictionary actually defines forgiveness as allowing for a degree of imperfection. This is allowing for imperfection. So yes, the majority on the court, 2 out of 3, were forgiving in dismissing the case without prejudice and allowing a new petition to come. The statute itself is kind of forgiving, 5 years. Why does the inquiry stop at that point? Practically, there's a kind of, we have to make the fact-finding not too difficult for the government, but I think there's also an implicit, whatever you did 5 years ago, you're a different person in the meantime. And yet, I have to say, I wonder what a court would have done if the person applying even had waited 5 years after committing genocide. Would the court then said, we're not going to look at it? Aren't some acts unforgivable? And to know what's unforgivable, let's start by looking hard at what forgiveness is, and then what does legal systems and rules currently do to seek or promote forgiveness? So by forgiveness, as I've already indicated, I mean a conscious, deliberate decision to forego rightful grounds for grievance and resentment against those who've committed a wrong or a harm. A grievance is a justified complaint, and I have to say, the notion of resentment has resonated with me right now because I don't feel very forgiving at this moment in the world. But there are a lot of resentments flowing in lots of directions, and it has made me feel even more how important it is to try to find ways to relieve the resentments that have occupied us in this country and in others. Forgiveness can offer benefits to an offender. It can relieve a sense of isolation. It can offer solace and acceptance. It can benefit even the victim, because letting go of resentment is a huge liberation. Even for some, regaining a connection or simply feeling empowered by the choice to forgive. But to forgive cannot be an obligation. It has to be a choice held by the one who was harmed. And declining to forgive itself is empowering. It's a way of saying, no, I have one thing left, which is the ability to forgive, and I'm not going to. It may be a way to demand accountability. Some people may find it impossible to forgive if the wrongdoer has not apologized. This came up in the discussion. What has the wrongdoer done in the meantime, or made amends? And even when a wrongdoer apologizes, a wrong has been done. And the desire for consequences, even the desire for revenge, I think should be honored. I think that's the source of a sense of justice. It's only when you have a sense that I have been wronged. Is there a view that actually there is a better way and I am entitled to more? A wrong should be made right, and intended harm should be met with a consequence, pursuing rights, correcting wrongs. This is the heartland of law. And crucially, some acts are unforgivable. But then the legal system itself often forgives. It creates time limits on consequences. It creates amnesty provisions. It creates other devices. And here's a danger. The even-handedness of the law may be jeopardized. With each act of forgiveness, what about another case? Is that going to be treated the same, or is that going to be treated differently? And courts and legislatures, at their best, speak to our highest hopes for fairness, for predictability, equality, freedom from bias and corruption. And exceptions can really mess that up. On the other hand, let's be honest. Forgiveness is built into any legal system that is run by human beings. There's the discretion of police, prosecutors, judges, juries. They exercise their discretion sometimes to let people off without punishment. Governors and presidents issue pardons. Courts reduce liabilities. Bankruptcy proceedings negotiate reduced payments on debt. Legal discretion permits flexibility, and it also permits bias, racial bias, other biases, unpredictability, lack of transparency, all at odds with the ideals of fairness and equality. So, what to do? Well, it'd be nice to say I have an answer, but I have a year to figure it out. What I do believe is that law should serve human ends, and the purposes of law should be our purposes. They're not some abstract thing up in the sky. They're not a rule book with a set of answers somewhere. And we should use law to help convert suffering into opportunities. Those opportunities can prompt forgiveness, perhaps, by individuals, or inject forgiveness inside the operation of law itself. So let's look a little bit more closely at how forgiveness already operates, at least in the American legal system. And that's a step towards considering when it should be used, when it should be promoted, when it should be restricted. So legal institutions and political actors can promote forgiveness by individuals, but also promote it. But also discourage it, I'm sorry. And law can itself enact forgiveness by foregoing consequences for wrongdoing. Here's 6 examples. People who borrow too much money to pay back can informally seek forgiveness from the creditor, the lender, or they can file for bankruptcy. It's otherwise known as a fresh start. It's much desired by people in debt because of credit card expenses. It's much desired by cities and sovereign nations that are swamped with debt, and student loans come to mind. As I worked on this subject last year as the dean of a law school, student loans came to mind. Right now, Puerto Rico is very much in my thoughts. Puerto Rico does not have the legal authority to declare bankruptcy because it's not a state, and it's not authorized by the Congress to do so. That's one reason they are in such terrible shape. And their struggle to convince creditors to restructure loan payments and secure extended time and actual forgiveness are obviously compounded by recent hurricanes and a difficult economy, currently $70 billion in debt. So can there be some mechanisms beyond bankruptcy? Second example, law can treat a doctor's apology to a patient as an admission of mistake, exposing the doctor to malpractice liability. Taking a different tact, 36 states, including Massachusetts, have an apology law, which prohibits the admission at trial of expressions of sympathy or apology by a medical practitioner. Only lawyers would call that an apology law, but it's an apology law. It just exempts this language from any subsequent trials. What the states adopting this law want to do is they want to remove the disincentive to have the normal human interaction of an apology and to encourage communication, a release maybe of resentment, grants of forgiveness maybe by patients or patient's family. This law, by the way, is very much supported by the medical profession because those states that have it actually have a reduced rate of malpractice cases. Third example, courts can require spouses on the brink of a divorce to try to mediate their disputes. A good mediator will call upon each spouse to express their grievances and desires of the other person. And even if they then go on and divorce, the spouses can become more understanding, more cooperative, maybe even more forgiving when they've tried to see the world through the eyes of the other person. I know a mediator who regularly sets the very first session with a divorcing couple at a terrible, terrible time. and then watches with kind of a smile as these fighting spouses agree that the worst person in the world is the mediator who set this terrible time. A fourth example, legal officials can ask a victim of a physical assault whether or not to prosecute. A victim who chooses not to proceed strongly affects whether or not the law is going to forgive, whether or not the law is going to give up. Some states in the context of domestic violence have adopted what are called no-drop rules, laws that treat the assault as a violation of public norms and requiring the prosecutor to go ahead regardless of what the victim thinks. You can probably imagine why. Here's the problem. A victim can decline to prosecute not because of forgiveness, but because of fear. And so these laws are efforts to try to take the responsibility out of the hands of the victim. And yet the victim can, of course, come back into the process at the sentencing time to offer forgiveness or its opposite. Fifth example, pardons. Executive power to pardon an individual who is charged with or convicted of a crime is a power that was held by kings, still is, and by government officials who think of themselves that way. Judicial processes can also operate in a kind of pardon, so you can move to have a criminal record sealed or to have it expunged so that there's no record, no one can get it. That's a kind of pardon, at least a limited pardon. And amnesties created by statute or by treaty can eliminate or reduce the negative effects of criminal charges or any other kind of legal violation. Governments can also consider barring consideration of a conviction, a criminal conviction, in other settings, like in an employment setting. Sixth example, I mentioned amnesty. Amnesty, I think, is it's a whole other category. It can be used to bar civil suits as well as criminal suits. It can be used with conditions on testimony or after a civil war with rebels surrendering their armaments or providing reparations or showing remorse. President Ronald Reagan in 1986 enacted an immigration law. It was dubbed Reagan's amnesty, somewhat in the news these days, permitting about 3 million people in the country who were here unlawfully to gain legal status. It was an amnesty. Amnesties can follow armed conflicts, when nations may decide not to have criminal trials or to address violations of human rights. And part of the peace process in Colombia right now, human rights activists who've been charged with rebellion have received amnesty, permitting both freedom and opportunity to apply for employment and go on with their lives. Similar proposal is pending right now in Uganda. And many people see this as a way to move on, to get out of the mess, while others criticize amnesties because people who may have committed seriously violent crimes go without legal consequences. And I just want to underscore this. This is the heart of forgiveness. It means letting go when there's justification to punish. It's not forgiveness if that quality is lacking. Novelist Doris Lessing once said, if you understand something, you don't forgive it. You are the thing itself. Forgiveness is for what you don't understand. In that context, I think it's worth having a little bit more extended discussion of probably the best example of amnesty in recent memory, and it's South Africa's Truth and Reconciliation Commission. How many are familiar with that? Most people are. Great. So it's over 20 years ago, on the road to the peaceful transition from apartheid to its current democracy. The Truth and Reconciliation Commission was adopted at the end of the negotiation process for the interim constitution. It was a word invented by the negotiators. Instead of a prelude, it was a postlude or something like that, a postamble to the Constitution, that there will be a process. And then the legislature enacted this process. Over 3 years of its operation, the TRC, as it's called, invited victims to tell their stories and invited perpetrators to apply individually for amnesty, conditioned on showing how their actions were limited to and proportional to political motivations. It granted ultimately 849 amnesties out of 7,112 that were filed. And victims offered testimony. The designers hoped that this process would prevent cycles of revenge and create public acknowledgement and a shared history. Its chair, Archbishop Desmond Tutu, reflected on his work and said, "Forgiveness means abandoning your right to pay back that perpetrator in his own coin, but it is a loss that liberates the victim." It has inspired a lot of debate and discussion. As it proceeded, the political cartoonist Zappo vividly demonstrated the problem with the Truth and Reconciliation Commission by showing Archbishop Tutu standing in a cartoon on ground that was labeled truth, and then there's a chasm, on the other side was reconciliation. Once you know the truth, it may be even harder to forgive. And I think, importantly, the TRC was criticized by people on all sides of the conflict. Studies show ambivalence, disappointment, mixed reviews, and one study indicates that very few people individually forgave. Only 7 people in a study of about 500 said that they forgave. And yet, even with its flaws, it provided a kind of ritual, a marker, a way, perhaps, to move on. I think we won't know how actually to evaluate the TRC until we know more about South Africa's future. It has, in the meantime, inspired efforts all over the world. There are over 40 Truth and Reconciliation Commissions in other countries following conflict. And it's also inspired a field. Academic studies have exploded. I've asked myself why such emulation, and I can't separate it out from the leadership offered by Archbishop Tutu and Nelson Mandela, inspiring narratives and images to communities thirsty for hope, particularly following violence. It offers a kind of third way, I think, between no response to atrocities and costly or controversial criminal prosecutions, on the other hand. In the United States, truth commissions have occurred in Mississippi following racially motivated crimes, in Greensboro, North Carolina, following the murder of anti-KKK Ku Klux Klan organizers, and in Maine, investigating the abuse of Native American children by child welfare agencies. I have questions. I have questions about truth commissions. I have questions about forgiveness. Consider the woman whose husband was imprisoned and tortured during the apartheid era in South Africa and said to the TRC, and I quote her, "A commission or a government cannot forgive. Perhaps only I could do it, but I am not ready to forgive." When a government says, "We forgive," on behalf of the people, who is the government to do that? The government doesn't have, actually, the authority to forgive. So what the government can do is the government can forego punishment, but that's not actually forgiving in the interpersonal way. I asked the commissioners of the South Africa Truth and Reconciliation Commission as they were holding their hearings about why didn't they make the amnesties conditional on apology. It's like a question that came up in our discussion. And they gave me an answer that has haunted me ever since. They said they decided not to make amnesty conditional on the offer of apology because they said then we could never know if any apology is genuine. I thought that was really insightful. And that's a window onto the difficulties of using law in this area because there are consequences and there's power. And therefore, if you're trying to actually nurture human communications, you distort it. And yet, one of the staff members of the Truth and Reconciliation Commission brought together informally the mothers of young men who were known as the Guguletu 7, who were killed by the secret police when a government informant said, "These are revolutionaries, they're going to do something bad." The informant came to the TRC and applied for amnesty. And the mothers were separately giving their own testimony as victims. And the psychologist, Pumla Gobodo-Madikizela, brought them all together and just thought they ought to meet. The informant, a black South African, the mothers, black South Africans. And it happens to be captured in a film, a documentary film, which I highly recommend, called Long Night's Journey into Day. The mothers begin the conversation by yelling at this informant and saying, how could you do this? How could you turn in your brothers? How could you take away our sons, our children? They chastise him. He hangs his head. He apologizes. And then one by one, each of the mothers forgives him. It's hard to understand. It's an informal setting. It's not compelled by the law, not formally organized by law. It's moving. I think it would be very troubling if it were compelled. And here's a troubling fact. 30% of the participants in the Truth and Reconciliation Commission reported feeling pressure to forgive. If you're in the presence of Archbishop Tutu, you might feel pressure to forgive. I think many of us remember in 2015 in this country an extraordinary, memorable public demonstration of forgiveness as some of the family members of the 9 people killed at the Mother Emanuel AME Church in Charleston, South Carolina, offered forgiveness to the shooter, Dylan Roof. Anybody remember this? Other family members expressed condemnation. One said she hoped that he would go to hell. Roof has remained unrepentant about firing 77 shots. Came back to mind with the terrible events of this past weekend. He said at his bond hearing that he intended to start a race war. Some members of the families of victims described how they were working on forgiving him. And others said that they forgave him, but that did not mean he should avoid punishment. The daughter of murdered Ethel Lance said, I will never talk to her again. I will never hold her again. You hurt me. You hurt a lot of people. But God forgives you, and I forgive you. It's a mystery. It reflects a kind of disciplined religious practice. Another surviving relative explained, we have no room for hating, so we have to forgive. Now, some people watching this have now said this is how white people set the terms for acceptable grieving by blacks. This is a long-time structure that deflects anger that's justified and treats systemic violations as if they're occasional. Philosopher Miesha Cherry criticizes calls by journalists, particularly upon black victims of white violence or state violence, to forgive because the requests are disrespectful of the victims. They normalize oppression. They underscore racialized roles. She says, are white victims ever asked to forgive this way? Others warn that there's a gendered dimension of forgiveness that raises cautions about using law to encourage it or to induce it. Studies suggest that women are better at forgiving. Why is that exactly? Is it that women have had to forgive? Studies of history and literary analyses of supplication and apology. Western culture often connects women with forgiveness and expectations that women will perform emotional labor. And society grants authority to men often in ways that contribute to pressures on women to forgive and to ask for forgiveness. And in this light, using law to promote forgiveness risks reinforcing already existing hierarchies, race, gender, differential power, in ways that put unfair pressure on people's emotions. And on the other hand, I'm running out of hands. On the other hand, some people, due to their religious tradition, their personal beliefs, view forgiveness as a worthy aspiration. And by forgiving, they express their own faith. So I'm running out of hands. I do think it can be emotionally draining not to forgive. And I do think it's a mistake to imagine that law has no impact on people's emotions, even with no forgiveness as part of it. Law can push people towards adversariness. So it seems to me not wrong to ask, can law make space for forgiveness? But how to do that without putting pressure, that seems a real challenge. But I'd separate that out. One question, therefore, is when should law make space for individuals to engage in apology and forgiveness, from the question when law itself should forego the consequences of wrongful action. And I do think on that one, we should be pushing much more. We're living, at least in the United States, in a period of the most incarceration in the history of the planet. There has never been a society with as many people criminally convicted and incarcerated. I think forgiveness would be a good thing for the system to inject. And I'd say the same thing about debt. The amount of debt, and I'm going to talk about both of those things. I think that we can make some progress on the big question that I have, which is, does it undermine respect for the rule of law to have more forgiveness by having less adherence to the rules as they're written down, by talking about concrete examples? And my two are child soldiers, with some general thoughts then about juveniles and criminal law, and then debt, with sovereign debt and consumer debt as the examples. And I'll be relatively brief about both, because I really hope we can have time to talk together. So child soldiers, international criminal law has made a big advance recently. First time in human history, there is a crime recognized of turning a child into a soldier. This was actually the subject of the very first case before the International Criminal Court. And Thomas Lubanga, the warlord in the Congo, was convicted of this crime, first time ever recognized. Interesting, convicted for 14 years. Compare that with criminal sentences in the United States. How, though, should the children themselves be treated? When children are abducted or coerced or enticed into assuming the role of a soldier, they're victimized by adults who take away their childhood and make them instruments of lawlessness and violence. But some join without being abducted or coerced, and some are drawn by the ideology or the opportunities for action, responsibility, the thrill of committing violence, the cause. Some who join under coercion later engage in terrible acts. They kill people, they rape people. Some stay for decades well past their childhood. Should their exercise of any degree of choice make them culpable, or should they be forgiven? International law has created a problem for us in this area. Every country in the world except the United States has signed the Convention on the Rights of the Child. Every country except the United States. I mean, every country but the United States says that anyone under the age of 16 should not be tried for any war crime or crime against humanity. So an adult can be charged with turning a child into a soldier. A child under the age of 15 cannot be tried. But 15 and 16-year-olds, 17-year-olds, they're not liable anywhere. And here's a problem. In many societies, they're adults. And there's a problem about reintegration often when they return home, and what should happen. So legal theorists would say forgiveness is not even the right concept if we're talking about minors. They're presumed to lack the intention, the knowledge, the control that's necessary for criminal responsibility. And certainly this makes sense if you're talking about a 3-year-old. But anybody here ever talked to a 15-year-old? They have some capacities that make them a little bit more like adults than the 3-year-old. One adolescent soldier explained to a researcher that he planned to return to Liberia so he could claim the benefits available to demobilize child soldiers and then return to the fighting. Some children in armed conflicts demonstrate choice in their involvement, and some find ways to actually escape and come back and escape and come back. It's a complicated story. And I have wondered whether we do a service to these 15, 16, 17-year-olds by saying, you are innocent, and no one's going to ever talk to you about what happened here. We'll give you job training. Researchers who work in this field have informed me more than I have that for many of the child soldiers, the real challenge is self-forgiveness. And Emmanuel Jal, who's a former child soldier who's become a very successful musician and rapper, has said this himself in his lyrics. He says, "I'm in another war, this time it's my soul I'm fighting for." And so I'm wondering if it's possible to imagine developing something like a Truth Commission, where people who've been child soldiers have an opportunity to tell their story and not be punished, but yes, explore the ways in which they had some responsibility or not. And nations and the international community could create a public process for people who participated in armed conflicts before they were 18. And maybe in doing so, the young people can not only help themselves, but help their societies. As I've thought about this, I've thought, boy, this would be a good thing for our juvenile justice system to explore. Our juvenile justice system started in 1899 with the idea that young people shouldn't be treated the same as adults. There should be a more forgiving place. Over time, it has become, if anything, more onerous than the criminal justice system for adults. And indeed, across the country during the Get Tough on Crime period from the 80s on, there's now automatic transfer of juveniles to adult court. Juveniles are regularly put in adult prisons. It is a pretty disturbing situation. For those who end up there, it is a likelihood they will never, never return to a path of success. So many communities are exploring what's called restorative justice, the development of opportunities for the victims and perpetrators to talk together, for wrongdoers to provide services, repair, repaint houses, engage in restitution, hate crime examples where individuals are actually invited to come and speak in schools. And there might well be opportunities for something like a Truth Commission also, to give these young people a chance to explain what was going on in their community that made this conduct seem like the right thing to do. Just a thought. I do think, of course, once you go down this road, you start thinking, what about adults? Why have this cutoff for people under 18? I think that's not a bad thought to be having and exploring. So my second example, forgiving debt. The concept of debt infuses Western and Christian morality, and it's not by accident that we use the word forgiveness in the Lord's Prayer and in bankruptcy, restructuring debt. And like spiritual forgiveness, bankruptcy represents the chance to start fresh. In 1789, before becoming the third president of the new nation, Thomas Jefferson argued to his friend James Madison for relief of each generation's debt. Maybe because Thomas Jefferson was in debt over and over again, he really thought about this a lot, and he worried, because he was Thomas Jefferson, he developed into a political theory, and he worried that one generation should not burden the next with its debts. And well aware of the debts incurred by the colonies en route to becoming a nation, he argued that with respect to future debts, would it not be wise and just for the nation to declare in the Constitution they're forming that neither the legislature nor the nation itself can validly contract more debt than they can pay within their own age or within 34 years? His friend James Madison said, "You have got to be out of your mind. This would jeopardize law, private property. We can't do this." And despite that argument, the Constitution of the United States, read it sometime, actually guarantees that there will be a right of bankruptcy. And in the business world, this has been perhaps one of the keys to the story of innovation in the United States, because declaring bankruptcy is often viewed as a cost of doing business. And there's not much shame involved in it. Individuals, another story. Individuals still undergo shame and personal difficulties, and some of that has to do with the law, some of it has to do with society. Big Apple Circus, anybody see the news today, is back a year after declaring bankruptcy. It can be a lifeline for businesses and families, even though it can be difficult. And cities. Detroit, Michigan. Jefferson County, Alaska, San Bernardino, California, Stockton, California, each have declared bankruptcy, and each is doing much, much better financially. But some debts lie outside of bankruptcy. In the United States, currently, student loans cannot be discharged in bankruptcy, except in the instance of death. Isn't that generous? So think about this. In the United States, for-profit companies that create student loans to target for-profit schools can declare bankruptcy, but the students cannot declare bankruptcy. Sovereign nations are another group that cannot declare bankruptcy, and their debts can be forgiven by creditor nations, private lenders, but it is very difficult to organize that. And only severe crises that threaten to spill over into the region push the European finance ministers to help Greece reduce its debt and extend its schedule of payments. And while defaulting on debt can seriously damage a nation's credit ratings and its access to capital, larger financial trends and improved domestic governance, pragmatic attitudes about the future mean that Argentina, of all countries, which has been one of the most indebted nations in the last 200 years, just successfully floated a 100-year bond, had no trouble selling it. So it is possible to have a fresh start even after something very difficult. I'm really interested in how the Pope and Bono have made this a cause. They're using the biblical notion of Jubilee year to clear a state of all of its debts and advocating for the forgiveness of the debt of the world's poorest countries. And they've made some progress on a multilateral debt relief initiative. Philanthropic efforts in the United States have taken a page from the practices of commercial debt companies. You know, the secondary debt market, they buy debt for pennies on the dollar, right? That's what the companies do. And then they go after people and they garnish their wages and so forth. So philanthropies now are buying consumer debt and student debt and medical debt and forgiving it. I think that's a pretty good charity. One group started during Occupy Wall Street, calling itself Rolling Jubilee. It raised $700,000 for 4 years, and it used it to buy $30 million of debt, which it forgave. I think that the government could promote that. The government could create tax incentives for people to do that. There could be other ways to make this kind of forgiveness more available, and that would be true for municipal debt, consumer debt, and so forth. So I'm going to close. I want to say that implicit in my discussion, there is another question, which is some wrongs are unforgivable. What are those wrongs? Philosopher Hannah Arendt claimed that we cannot forgive absolute evils that are too large and too radical to punish. Others say that's exactly when you need to forgive. I find it a really hard question. As Judy said, this is a kind of sequel to a book I wrote before, and people have asked, ever since I wrote a book called Between Vengeance and Forgiveness, well, why not forgiveness? So that's what I'm struggling with. I do think that a focus on forgiveness in the law will help us expose the imbalance of the current practices. So, for example, we have a doctrine called harmless error in criminal law. Guess who gets to claim it? The government. Criminal defendants never get to claim harmless error. Or another imbalance, during the subprime crisis, banks were allowed forgiveness for not being able to have their paperwork, but the consumer was not allowed. I think a focus on forgiveness could be very helpful, and it might actually help us specify the circumstances under when it should be promoted, when it should not. A group of social scientists asked Latin Americans and Western Europeans about forgiveness and found that a majority of people in both regions favor forgiveness, even without a change of heart or an apology, anything on the part of the violator. But interestingly, those in Latin America were more likely than those in Western Europe to accept as the forgiver someone other than the offended person. So this issue I said before that the government cannot forgive, that may be culturally specific too and worth thinking about. I think we have to guard against turning to forgiveness solely when more robust justice is not available. And we should be careful not to use the law to distort private emotions or to undermine the commitment to treat similar cases alike. And yet I think we should consider how and when law can usefully make space for forgiveness or forgive itself. I've been thinking about Mr. Rapui. I think he deserved consequences for his actions, but how striking it was that the jury and the judge, all the judges, thought some forgiveness was due. There's a man named Paul Bowes. I don't know who he is or was, but he loved to craft sayings that would be quoted. He wrote before Twitter, but he would have loved it, and now he'd have double the letters space. Here's one of his quotations. I like it so much, I'm going to end it with it. He said, "Forgiveness does not change the past, but it does enlarge the future." Ultimately, forgiveness points towards the future, not just the past, and I think it offers an important dimension for designers and agents of the law. Thanks.